So today we have Josh Blackman. So this is going to discuss originalism and why the text matters, and he's going to go through various cases and Scalia's take on originalism as well. So our commentator for today is Professor Sanders. Steve Sanders is a professor at the law school. He's been here since January 2013. He practiced for several years at Mayor Brown. Previously, he taught at University of Chicago and also the University of Michigan as alma mater. So he teaches constitutional law, family law, civil rights law. He's, in addition to his scholarly publications, he's written for the Huffington Post, Scotus Blog, the Chronicle of Higher Education, other print and online media. So our speaker for today, Josh Blackman. He's a professor at Houston College of Law, specializes in constitutional law of the United States Supreme Court and the intersection of law and technology. Josh is an author of the critically acclaimed Unprecedented, the Constitutional Challenge to Obamacare, and also Unraveled, Obamacare, Religious Liberty, and Executive Power.
Which comes out next week. We'll buy a copy.
Little plug there. So,
that was a big plug, really.
You have coupons for discount?
I have cards for who wants.
Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's an adjunct scholar at the Cato Institute, so libertarian think tank in Washington, D.C. He's also the founder and president of the Harlan Institute. He's authored over 3 dozen law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, and USA Today, LA Times, and other national media. So without further ado, Josh Blackman.
Thank you. Everyone. Thank you. It's a pleasure to be here. I've been to IU a few times now, and this, I think, is the strongest crowd yet, so you're learning to love me. My talk today, and my good friend Steve Sanders will be responding, is on originalism. And it's impossible to talk about originalism without talking about Justice Scalia. As I'm sure all of you know, he passed away last February in the middle of a very, very contentious Supreme Court term. It's often said, we are students of the Enlightenment. Well, you are all students of Scalia, whether you realize it or not. You have come of age in an era where originalism and textualism are theories that are debatable, right? Some like it, some don't. If you had gone to law school maybe 30 years ago, sitting in this very classroom, the notion of originalism would have been laughed at. It would have been scoffed at. The notion of textualism would have been laughed at. If you go back and you read opinions from the 1970s and 80s about statutory interpretation, you will find decisions that say, well, because the legislative history is ambiguous, we turn to the text of the statute. No longer. Through sheer force of personality and persuasion, Nino Scalia changed the way that we look at statutory interpretation and changed the way we look at constitutional interpretation. So now, whether you're Stephen Breyer or Samuel Alito, you start with the text, and maybe you deviate after that, but you start with the text. With constitutional history, whether you're Nino Scalia or John Paul Stevens, you start with the history of the Constitution. What I want to talk to you about today is how Justice Scalia came to revolutionize constitutional interpretation through this mode of originalism. What are some of the strengths of his views? What are some of the weaknesses of his views? And my friends, there are some weaknesses. And whether Scalia was, in fact, a committed originalist, or as he described it, a faint-hearted originalist. I will close with a discussion of 3 cases from Justice Scalia's tenure that one where he almost certainly didn't like the result, the other where he certainly liked the result, and the third where he said, I like the results of screw originalism. And we will get there in due time. So to begin, I want to discuss a lecture Justice Scalia gave in 1988. It was called Originalism, the Lesser Evil. The Lesser Evil. Now, he never pretended that originalism is perfect. He simply argued that it was better than everything else. And he would often tell this story, which I love telling to law students. So imagine two people being chased by a bear, right? One of them says, hey, you're not going to outrun the bear. The other one says, I don't have to outrun the bear. I only have to outrun you. Ah, there it is, yeah. In this sense, Scalia explained that originalism, though perhaps not the best or the fastest approach, was better than the other options. So what is originalism? Now, let me disabuse you of one notion. It is not focused on the intent of the framers. People often use that phrase incorrectly. There was an older strand of originalism, advanced by Robert Bork and others, that said, what was the intent of the framers? The reason why this approach was never very effective is that there were a lot of framers. And there were a lot of people ratifying the Constitution. And there were a lot of different individuals involved in this process. So trying to drill down to the single purpose or the single intent of an entire continent, really, was always a foolhardy task. Rather, Scalia's contribution to originalism in the 1980s was to shift from original intent to what's called original public meaning, original understanding. How were words understood at the time of their drafting? So rather than trying to, scan the minds of James Madison and Alexander Hamilton, these other people, Scalia said, let's look at the meaning of words. And this was a task that could be done with more accuracy. We have dictionaries from the time. We have various newspaper articles. The Federalist papers, my friends, were a series of newspaper essays. We have various documents which shed light on the meaning of the Constitution. So we have provisions like confrontation. We have provisions like right to bear arms. We have provisions about the right to freedom of speech. And these were terms which people used, people of intelligence, and they gave meaning to it. So an originalist says, okay, I have this provision in the Constitution, right? And all of your pocket constitutions, right? You open it up, you turn to a phrase and said, okay, the right to keep and bear arms. How is that phrase understood in 1791? Now, why did I pick 1791? Anyone know? You should all know. What was 1791? The year what was ratified? Exactly. In 1791, the Bill of Rights was ratified, right? How would a person, a reasonable person in 1791 have understood this phrase? That is originalism in a nutshell. I can explain it to you standing on one foot, as it were. Now, here's where Justice Scalia admits the rubber hits the road. For most of our nation's history, the court hasn't always been so keen on originalism. They've used what Scalia referred to as an evolutionary approach to the Constitution, or what some of you may have heard called a living Constitution approach. Now, what is living constitutionalism? It's the general notion that courts can interpret the Constitution based on contemporary values as they see them as time evolves. So while something may not have been unconstitutional in 1789, it may have become constitutional in the year 2016 or whenever we happen to be. So Scalia sets it up like this. He admits that his framework has some subjectivity, right? Historians often do not agree on history. There's often debates about what a provision may have meant, but at least it has some basic fixed point that you're trying to find a meaning to. Whereas with the evolutionary approach, it is entirely subjective. It is entirely leaving it up to judges to decide the meaning of phrases. Scalia had his image of the Constitution as an empty bottle. And then a judge of the day pours a little bit in, pours a little bit out, and decides what the content is. So while it's certainly true that judges are not historians, they're not. And it's certainly true that historians often disagree. Judges at least have the competencies and the capabilities of trying to find the meaning of words. I mean, this is what you're all sitting here for 3 years learning. How do we decide the meaning of a word in a statute or regulation? With the evolutionary approach, the meaning of the words is irrelevant because they're trying to decide cases based on fundamental values. Scalia would often say, why do we have judges on the bench then? Let's put ethicists, right? Let's put philosophers. right? What do I know about the death penalty, right? What do I know about abortion, whether it's good or bad? I don't know. Religionists, theologists on the court, let them decide these difficult issues. Or maybe, as Scalia would say, let the people voting and let the elected officials decide these sorts of philosophical issues. Now, the common criticism of Justice Scalia's approach is, well, you know, if we have originalist judges, we wouldn't get to certain decisions which we hold sacred, right? We wouldn't get to Pickett, Brown versus Board of Education, or maybe Loving versus Virginia. This was the case involving a ban in interracial marriage. Pick your favorite case and say, there's no way this can be conducive with originalism. I think there's two responses. First, I think you may underestimate originalism. There's actually sufficient scholarship explaining how Brown can be reconciled with the 14th Amendment's original understanding. There is. It exists. You can agree with it or not, but there are some arguments here. But the second argument, this I think is probably the more powerful one, is, so what? Does anyone think that Brown v. Board ended school segregation? No. By its own terms, it didn't. It said desegregate with all deliberate speed. Did the Arkansas governor listen to the federal courts when they said desegregate Little Rock High School? No. Had those students make it in? President Eisenhower sent in federal troops to escort them in. So I think you vastly overestimate the power of the Supreme Court. You're in this law school environment where you put the Supreme Court on this pedestal as the sole expositor of our rights, and without the Supreme Court, we can't do anything. Rubbish. Rubbish. It was a political process that did all those amazing things that you love. So don't think that the courts have to be the answer to every single problem. It's certainly not true. But even so, Justice Scalia's approach to originalism had a very, how should I say, uneasy relationship with stare decisis. As you all know, stare decisis means you stand by precedent, right? You stand by the decisions of the past. How can an originalist live in a world where we have all these non-originalist precedents, right? How can originalists live? So Scalia explained it like this. He was a faint-hearted originalist. In other words, he would not reverse a precedent that, in his mind, was fairly well established. It's been around for a long time. But here comes the subjectivity. How do you decide how long a precedent has been around for it to be super duper precedent, right? So for Scalia, I'd assume he would not be willing to overturn Brown versus Board of Education. He was willing to get rid of Miranda in a case called Dickerson. Till his dying day, literally, he'd be willing to get rid of Roe v. Wade and then Planned Parenthood versus Casey. So the decision of which precedents are super duper precedents and which precedents are not has a lot of subjectivity, which originalists sought to reverse. Now, Justice Scalia's a colleague in the court, Justice Thomas, he is an originalist that is committed. He does not believe in stare decisis for constitutional decisions. He's made that very clear. He would overturn just every case he finds. You often find in a Thomas opinion or a dissent occurring opinion, like, well, this is not the correct case, but I'd revisit the New Deal, right? This is not the correct case, but I'd revisit every precedent in the last 70 years of the Commerce Clause. And he would, without any compunction whatsoever. So people often say that, you know, Thomas is Scalia's lackey. Thomas is the originalist on the court, and now, indeed, the only originalist. Now, in terms of precedent, Scalia said, and this he gave a lecture at the University of Chicago a couple years ago. He said, you know, I'm not going to go back and rip out a century's worth of jurisprudence. I ask myself things like, you know, how bad was the decision? How well has it been accepted? Does it permit me to function as a judge? And if you read his dissent in Planned Parenthood versus Casey, he sketches this out. He says that Roe v. Wade is entitled to no precedential value. So even with this sort of faint-hearted originalism, he has called a switch. Some cases he'd be willing to revisit. Some cases he would not be willing to revisit. Okay. I'd like now to turn to a couple of decisions rendered by Justice Scalia that I think illustrate different approaches to originalism. The first is a case called Crawford versus Washington. Did any of you study this case? Good. See a couple who are shaking their heads. So the Sixth Amendment has a confrontation clause, and it says, in all criminal prosecutions, enjoy the right to be confronted with the witnesses against them. This is a provision that stretches all the way back to our Anglo-American roots, where you would often have these trials where people would accuse someone, but outside the presence of the defendant. And there would not be the opportunity to cross-examine, confront the accuser. So this is in our Constitution. Now, there was a decision from the Supreme Court, I think in the 60s or 70s, called Ohio against Roberts. And this decision, and I can only describe it as a loose decision, said, well, you don't actually need confrontation. You can admit out-of-court hearsay of the evidence into court, so long as it's, quote, reliable. That was the phrase, right? Does it have guarantees of trustworthiness? So you have these judges admitting all these out-of-court statements, which can be used to convict a person. Okay. So if you have Scalia, Scalia was a law and order conservative. Do you think he cares much for criminal defendants, right? The person who perhaps, this was actually a case decided during his tenure. You had a man babysitting a child. And someone else in the house sees the guy running out of the child's room. And the child says something like, he touched me. Okay? And the child told that to this other person in the house. There's a prosecution for a rape. The judge admits that statement, that this guy touched me. The second-hand statement that the person said, the kid told me he was touched. They don't have the child testify for reasons you can imagine. Can you admit that statement of the third party who said, oh yeah, the child said that he was touched in a bad way? The court, under this case of Ohio v. Roberts, upheld the admission of the evidence, and the person was convicted. Person was convicted. Do you think Scalia gives a damn about this child molester? No. But Scalia believed in the Confrontation Clause. He believed in the Confrontation Clause. He said, no, you need to confront your accuser, even if that means forcing a child to testify in court against his molester. That's some serious business right there, right? So over the course of maybe almost 20 years, Scalia issued dissent after dissent saying we need to revisit the original meaning of the Confrontation Clause, even though as a law and order conservative, he couldn't care less about these defendants. Finally, in, I think it was 2003, probably after a year or two, he issued the decision in Crawford against Washington. And Crawford said the Constitution means what it says. You have to confront your accuser in person. None of this hearsay out-of-court evidence. You confront your accuser. And who joined him? It wasn't the conservatives. It wasn't just Chief Justice Rehnquist. It was the liberals, Breyer and Ginsburg and the others. They joined him. So here we have a case where originalism yields a result that is entirely opposite of what the law and order justice would do if he were king. Scalia said, this was his quote, I should be the pinup for the criminal defense bar because my originalist philosophy leads me to defend rigorously the right to a jury trial and to defend the Confrontation Clause, all of which benefits defendants who I'd rather see put away. But once you show me the original thinking, I am handcuffed. I cannot do, this is a quote, the nasty conservative things I would like to do to the country. You can use your imagination what those nasty conservative things are, but these are his own words. Another case he often likes to describe is Texas versus Johnson. This was a flag burning case where he voted, he was the fifth vote, to invalidate the conviction of a guy burning an American flag. This is like, the Colin Kaepernick of days old. He was burning the American flag at the RNC convention in Dallas. And Scalia would also say, these scruffy hippies, if I was king, I'd put them all away. We had a constitution. So I think this is perhaps Scalia at his best. You have an original decision where he does not agree with the result. This is one checkpoint you can use in your own career, right? Are you being faithful is if you reach a result that you would disagree with. That is, if the legal analysis yields result A and you would vote for result B, that is your check that, okay, maybe you're doing something right. It'll happen in your career, and then okay, I'm in good shape. The second case I want to talk about is one where Scalia's originalism reached a result that he certainly agreed with as a matter of policy. And this is the case of District of Columbia against Heller. This was the Second Amendment case. So the Second Amendment provides, as you all know, a well-regulated militia being necessary to the security of a free state, the right of the people to keep their arms shall not be infringed. Okay, what is the meaning of this provision? And I'm not going to bore you with all the details, but needless to say, this was appealed to the Supreme Court. And a 5-4 decision, Justice Scalia said that the original understanding of the Second Amendment is consistent with an individual right to bear arms. What does that mean? It has nothing to do with service in the militia. Right? This is a right which we have from our Anglo-American tradition. And Justice Scalia's opinion traced it back to Blackstone and common law rights, and had a fairly rigorous decision. Now, the most interesting part of Heller for our purposes, and I don't need to talk about the details, the majority, is the dissent. The dissent from Justice John Paul Stevens was originalist. Stevens didn't say, you know what, we're living in a 21st century world, things are different, circumstances have changed. He tried to also trace how the framers would have intended the Second Amendment to be applied. Now, I chose my words carefully. Stevens' dissent was one of original intent. He did not use original meaning, which is why I think he went astray. But he tried to match originalism with originalism. That is significant. And I think that's perhaps the greatest legacy of Scalia, that you now have a theory so legitimate that the dissenting justice feels compelled to do the same. It would have been easy for Stevens to have said, you know what, this Constitution doesn't matter. We live in a modern society with gun violence. We should let the state do what we want. That's actually what Breyer did. Breyer's dissent was a different story. But Stevens tried to match firepower with firepower. So the Second Amendment decision, Heller, I think, was perhaps the apogee, the height of Scalia's influence on the court, because he forced the other side to come to play with him. I'll note that originalism today is not merely a conservative enterprise. There are liberal groups, progressive groups, that have employed originalism to yield progressive results. So there's a group called the Constitutional Accountability Center. They were founded by Doug Kendall, a very prominent attorney. And they filed briefs in court arguing that the original meaning of the Constitution supports the right to same-sex marriage, or supports the right to education, or supports the right to a host of other things, right? That we disagree on the history is not bad, right? We can reach different results. What's critical is that they were adopting Scalia's methodology. They are adopting Scalia's methodology. We're no longer in the place where we say we have these empty bottles, fill them with whatever you shall choose. The final decision I'd like to talk about before I hand over to my good friend, Professor Sanders, is a case where Scalia reached a result that he agreed with without following originalism. And this was a case of McDonald against Chicago. So, common law refresh. In Heller, the Supreme Court held that the Second Amendment prevents the federal government from banning handguns. But there was an additional step that was needed, one of incorporation, which you should have studied. Incorporation is the process by which the Bill of Rights are extended to the states. So, the First Amendment says Congress should make the law respecting the freedom of speech. Can Indiana abridge your freedom of speech? So over a fairly lengthy process, the Supreme Court says, no, Indiana cannot do that. Why? Well, we have the 14th Amendment, and the 14th Amendment says a state can't deprive you of liberty. And what is the meaning of liberty? It's the freedom of speech. This is a doctrine known as substantive due process. The idea that the 14th Amendment is not merely procedural, it has substantive guarantees, among them the first 8 amendments in the Bill of Rights, including the First Amendment. Now, Justice Scalia has been a vigorous critic of substantive due process. He has called it an oxymoron. He has called it babble. He has called it every mean thing you can say in the book. He says the 14th Amendment only protects process. It does not protect rights such as the right to abortion, the right to privacy. Yet, how do you get the Second Amendment to the states? The majority opinion, there's actually a plurality by Justice Alito, said, okay, we're going to use substantive due process to incorporate the Second Amendment. Scalia joined that. Scalia went along with using substantive due process, which he says was not originalist, to incorporate the Second Amendment. He said, this was from his concurring opinion in McDonald, I'm not going to overturn everything that's been decided, but I will not apply so-called substantive due process in the future. In other words, I'll do it here, but nowhere else. So I called him out for hypocrisy. Steve may say, oh, he's hypocritical. I agree. Scalia was not consistent. As is so often the case, people do not practice what they preach. But you know who was consistent in that case? Justice Thomas. Justice Thomas's concurring opinion was a treasure. So there's another provision of the 14th Amendment, which I hope you study in common. If you haven't, go yell at your professor, called the Privileges or Immunities Clause. Now, we all think here that due process is the big thing, right? This is the center point of the 14th Amendment. You're wrong. The crown jewel of the 14th Amendment, which was meant to protect a lot of rights for people, was the Privileges or Immunities Clause of the 14th Amendment. But in a decision called the Slaughterhouse Cases in 1880, might be up here, 1880 or 1878, the Supreme Court basically read the Privileges or Immunities Clause out of the Constitution. It said it doesn't protect any rights. So it's this silly little thing. Don't ignore it. You want to know something? The Bill of Rights was meant to be extended to the states through the Privileges or Immunities Clause. Read the debates of the 14th Amendment. They said, look, we can't have these states denying the freedmen the right to make newspapers. We can't, have these states denying the freed slaves the right to practice religion of their choice. They would shut down abolitionist churches. And oh, by the way, we can't have the states depriving these freedmen the right to arm themselves against the Ku Klux Klan. Oh, yes, my friends. A core component of the Privileges and Immunities Clause was to arm the freed slaves to defend themselves. In fact, I've argued the case for an individual right on the 14th Amendment is even stronger than under the Second Amendment. There's history here on point. Justice Thomas said, look, we got this clause of the Constitution. I'm not going down the substantive due process route. Let's go to PRI, Privileges and Immunities. Did Scalia join? Did Scalia join Thomas's opinion? Broke my heart. No, he didn't. Why? Because he was afraid, to use a phrase I used in an article, that this would open up a Pandora's box. That there may be other rights, unenumerated rights, protected by privileges and immunities, and that would spook at Scalia, and he didn't like that result. He blinked. He blinked. And I think that I wrote a piece at the time saying Scalia jumped the shark. I think that was basically if Heller was his apogee, if I can use the phrase, McDonald was his denouement. That was his downward slope. And I think it's unfortunate. But let's not lose sight of the fact of how he fundamentally transformed our constitutional jurisprudence. That I'm sitting here in Bloomington having this debate. I would not have had this debate 30 years ago. I wasn't alive yet. But I wouldn't have had this debate that long ago if I was here, right? 30 years ago I was alive. I was a toddler, right? I would not have had this debate. We all owe Justice Scalia a debt, whether you agree with the results or not, for transforming methodology. And I think he will be remembered as one of the most influential justices of the 20th century. And the fact that we're still talking about him for years to come will prove that. Thank you all so much. I'll turn over to my good friend, Professor Sanders, and I look forward to your questions afterwards. Is it okay if I move this?
Yeah.
She can shut it.
Don't close. When Josh calls me his good friend, I think he's not engaging in that sort of phony baloney that people in Congress do. I mean, I'm genuinely fond of Josh, and we've interacted at conferences and talked a lot. I think he's one of the smartest and most prolific and most energetic common law profs out there. And so you guys are lucky that he is willing to come back and again to Maurer. Actually, Josh stole some of my thunder in some ways by acknowledging many of the limitations of originalism that I had planned to talk about. We didn't exchange texts in advance or anything like that, so I plan to say some things that intersect or maybe go beyond what Josh said, and he may have some responses to that. Basically, I want to make 5 arguments. Originalism is certainly not required by the Constitution itself, and I don't hear Josh making any argument that it is. Second, that it's too often indeterminate. Again, something that his remarks, I think, pointed to in some ways. 3, that it's bad policy, that it's just a bad idea. 4, that its own proponents have vast disagreements about what it is and what it looks like and what it requires. And 5th, that it really is, for the most part, politically driven. It is not just a neutral methodology, despite the fact that Justice Scalia could sometimes reach what would be considered to be liberal or progressive results. So first, all the claims about originalism, that it's a superior in some normative way, that it's better than the alternatives, may be true so far as, that may be a legitimate argument so far as it goes, but there's no argument that it's actually what the framers intended or expected, or the founding generation intended or expected. In fact, I think there's a better argument to the opposite, that what we know about those who drafted and ratified the Constitution, what the kind of dialogue, legal and constitutional dialogue they were accustomed to, cuts against the idea of originalism. The founding generation was very familiar with what's sometimes called today popular constitutionalism, what was then often referred to as the customary constitution. The idea that constitutional principles do not need to be written down, or when we do write them down, that they are not the end-all and be-all, that it is not necessary or even possible to enumerate every single rule or value or right that we think is protected by our ideas of liberty and by our ideas about the relationship between government and the people. Larry Kramer, who's written a lot about popular constitutionalism, refers to this as customs and deep abiding traditions and values that are refracted through a written text. He talks about the customary constitution as using a text that provides broad guidelines, but which requires pragmatic accommodation and ongoing adjustment. Again, I think there's a lot of evidence that this idea of a customary unwritten constitution, which Britain still has today, and of course that's part of our legal heritage, cuts against the idea of originalism and is much more in sync with the idea of a living constitution, a constitution that develops through precedent and through common law reasoning. Originalists focus on an ancient piece of text full of majestic generalities like equal protection of law or liberty that was never intended, I would argue, to hold all the specific answers to the constitutional questions that we deal with today. Second argument, originalism is too often indeterminate. It requires lawyers and judges to pretend to be historians. There's often evidence on both sides of an issue or insufficient evidence from which to draw firm conclusions. In law school, you will sometimes hear this phrase called law office history that real historians use, and it's not intended as a compliment toward lawyers. District of Columbia versus Heller, as Josh said, Justice Scalia and Justice Stevens both engaged in some form of originalism in their analysis, but they came to a complete deadlock, a complete stalemate as to the ultimate result of what the Second Amendment means. But Justice Scalia won in the end, not because he had the better originalist arguments necessarily, but because he had the votes. They were both doing originalist analysis, but Justice Scalia had the votes and Justice Stevens didn't. Josh has written a lot about the Obamacare case, the individual mandate case, NFIB versus Sebelius. And so I was thinking, you know, what would John Marshall, certainly an authority on the original public meaning of the Constitution, have thought about the Obamacare individual mandate? I'm curious to know if Josh has thoughts about that.
It was unconstitutional.
Given that Josh has written a whole book about it. I mean, given what we know about Marshall's views about legislative power and the necessary and proper clause, I guess I would have thought there might have been at least a good argument that he might have been okay with it. He said Marshall said a constitution is framed for ages to come and is designed to approach immortality as nearly as human institutions can approach it. The government, which has the right to do an act and is imposed on it, the duty of performing that act must be allowed to select the means. The nature of a constitution requires only that its great outlines should be marked, its important objects designated, and the minor ingredients which compose those objects be deduced from the nature of the objects themselves. So anyway, there's dicta in Marshall's opinions that I think support a more expansive understanding of the commerce power. But then I thought, you know, this whole question, what would John Marshall or the founding generation have thought about the individual mandate, or more precisely, how does the individual mandate comport with the original public meaning of the Commerce Clause, is simply absurd to even see that we should be arguing on that territory. Our understanding today of health and disease, our customs of how health care is delivered, the very existence of something called health insurance, the now well-settled, well-accepted idea that government has some legitimate role to play in promoting the health of its citizens, are notions that some of us have about health care as a human right. The framers, the founding generation, the original public meeting would have had no context for any of that. So why should we care what they would have thought about that, how they would have thought that their words should apply to this current controversy? Their own writings bear no evidence whatsoever that they expected us to do so. Third, originalism is bad policy. It's the classic example of the dead hand problem. As David Strauss notes, originalists have no real answer to Thomas Jefferson's famous question, why should we allow people who lived long ago in a different world to decide fundamental questions about our government and society today? Again, I suggest the better alternative is a common law method of constitutional interpretation, sometimes called the living constitution, where precedent builds on precedent, is occasionally extended to take account of new empirical realities, new knowledge, new social understandings. Mainstream originalists, and I'll talk more about this, though not all, think it's just absurd to believe that the framers of the 14th Amendment would have approved of the idea of using the Constitution to protect sodomy or gay marriage. I think it's absurd to suggest that we should be constrained in our constitutional thinking by the entirely primitive understanding of homosexuality as a scientific and medical and psychological and sociological phenomenon, that we should be constrained by the primitive understanding of homosexuality that existed in 1868. That leads me to my fourth point. It's the proponents of originalism too often can't agree on what it actually means. Religious conservatives like Robert George at Princeton are calling for open defiance. They're like the Southern governors after Brown versus Board of Education, calling for open defiance of Obergefell, the gay marriage decision. On the other hand, Ilya Somin, who Josh tells me is not really an originalist, but writes about originalism, argues that it's no longer possible to claim that there is no serious originalist case for striking down laws banning same-sex marriage. George and Somin both claim to be engaging in originalism. They're both Federalist Society certified experts who go around the country talking about it, but they have completely irreconcilable views about one of the key legal issues of our time. Will Bode from Chicago, who was here in this room a couple of years ago talking about originalism, argues that originalism can be defined at a high enough level of generality that it can encompass almost the entire body of existing Supreme Court jurisprudence, an argument that would certainly come as a surprise to Justice Scalia or Justice Thomas. Now, I think it's, don't get me wrong, I think it's great that the Federalist Society is a big tent and that Josh and I can debate and you all can debate and think about these questions. That's great, that's what law school's for. My only point is it should give us pause before the rest of us are asked to embrace a supposedly superior interpretive methodology, or a methodology that is said to be better than the alternatives. Josh acknowledges, I think perfectly correctly, perfectly appropriately, that there are simply many questions to which originalism does not have clear answers. One originalist can come to one conclusion, another can come to a very different conclusion. In the days of the Reagan administration and the Edward Meese Justice Department in the 80s, the sort of environment out of which both Justice Scalia and the Federalist Society came, originalism was most often associated with judicial modesty, judicial restraint. Judges must stay in their lane and give a lot of deference to the elected branches of government. But today, once again, even on this issue, there's a major split. One part of the originalist camp, the more libertarian camp, is very much focused on what they call judicial engagement. Many old school originalists claim to honor departmentalism, this idea that all three branches have the capacity and the right to make constitutional judgments. But the more libertarian camp, of which I think Josh is a part of, he's written with Randy Barnett at Georgetown, have argued for judicial supremacy in constitutional interpretation and an aggressive judicial intervention into politics. Josh can correct me if I'm wrong in interpreting that, but I'm referring specifically to arguments they've made about the Obamacare decision, about the NFIB decision. They've said judicial restraint is a vapid concept. Judges must follow the Constitution wherever it may lead them and let the chips fall where they may. And so that means we should ignore a popularly elected Congress and ignore the key legislative agenda of a popularly elected president. And if they think that an originalist methodology requires striking down the individual mandates, so be it. That's what the Constitution requires. Precedent, as you know, stare decisis, as Josh discussed, is a cornerstone of our law because it provides legitimacy to law. It promotes predictability and consistency. But the most extreme or most aggressive originalists, like Justice Thomas, would blow that up. But Justice Thomas right now is pretty lonely. He applies his project about absolutely pure originalism very quietly in a very lonely way, in a way that has not attracted the support of his colleagues or the mainstream legal community or very many majority opinions. And so I'm simply saying, before you embrace the idea of originalism, by all means talk about it, debate it, investigate it, but ask which of the various, sometimes incompatible versions of originalism you're being asked to embrace. Finally, I think the evidence shows that originalism is political. Yes, Justice Scalia would sometimes point to a few cases where his originalism led to a progressive outcome or an outcome that liberals could get on board with, like First Amendment right to burn a flag or maybe the Confrontation Clause. But originalism is usually about reaching conservative outcomes, and it's expected to reach conservative outcomes. There's been plenty of commentary that says Justice Scalia claimed to be an apostle of judicial restraint and deference to the elected branches, except when the elected branches did something that he didn't like. When it comes to the Confrontation Clause, the idea that the idea of expanding the rights of criminal defendants is associated with progressive causes, but a flip side of that is Justice Scalia also would insist, when the Confrontation Clause is applied, let's say you had a child who had been the victim of a sexual molestation, it would be really traumatic. We know today through science and psychology the effect that actually confronting one's aggressor in court might have on an abused child. Scalia didn't care. Scalia said it's not confrontation unless that kid is in the courtroom. Half measures like letting the kid testify on videotape or something like that, no good, don't fit confrontation, don't tell me about what this gobbledygook about social science and psychology tells us. It has to be pure confrontation. So, maybe that's sort of a nasty conservative view. I don't know. Something that comes out when you actually apply the Confrontation Clause in its detail. Josh and his colleague Randy, whose work I very much admire in many ways, wrote recently in the Weekly Standard that the next Republican president should really take what I think is fairly described as a bare-knuckled approach to getting his Supreme Court nominees confirmed.
You wrote this before Donald Trump was even a thing.
Okay, all right. So not Donald Trump, but some other Republican president should take a bare-knuckled approach to getting his Supreme Court nominees confirmed no matter what. And when you read their piece, I think that goes hand in hand with the expectation that such a justice, that the Republican president must fight tooth and nail in a bare-knuckled way to get on the court, would be practicing originalism. An originalist may claim that he or she is just following orders that were laid down by the drafters and the ratifiers, but its actual track record, I think, shows that it's not a value-neutral, apolitical methodology. It is a conservative methodology, albeit, as I said, one that religious conservatives, traditional movement conservatives, and libertarian conservatives all seem to have different visions of and different expectations of. So, think about it. That's why the Federalist Society, a conservative legal organization, flies my friend Josh here to talk about it, and it's why the Federalist Society will be footing the bill for the lovely lunch he and I will have at Pinches after this program. I want to thank you for after your questions.
Thank you so much. And we are indeed friends. So because as people reaching for their backpacks, I'll turn to the Q&A portion, and maybe I'll try and address some of us questions. Q&A, if not, it'll be at Finch's later. So questions? Yes, sir, in the back.
Josh, I have a question for both. I
appreciated your ability to talk about Scalia passing consistency of originalism. Where would you put is Citizens United in current? I thought that was a stretch to call citizens.
Not about 6 years. So I don't quite exactly remember it, but my general recollection. Found it. I wrote a blog post in 2010 on this exact topic called Originalism of Scalia. Steve, you go first. I'll read what I wrote, then I'll come back to it.
Sure. I mean, I guess I would openly acknowledge that well, at least if it's between originalism and the living constitution or common law constitutional interpretation, it's two major competing approaches. Sure, I think they're both underlain with values. I think to the extent that progressives support what's called the living constitution, it's in part because they have a faith in the sort of, the continuing evolving progress of men and women through knowledge and empirical learning and moral understandings that we're not the same people we were 100 or 200. Why should we be bound by a text? So, yeah, no, I have no problem acknowledging that the living constitution is consistent with what we would consider progressive ends. That's different than saying it is always results oriented, but I think there's a lot about the methodology that is consistent with like progressives and
Okay, so I reread the post I wrote on January 21st, 2010 about this. So the long and short of it was that Scalia contended that, as a matter of original understanding, the framers viewed corporations as having rights. If I can go on a soapbox for a minute, the entire notion that corporations have no rights is a fiction. For time immemorial, corporations have exercised rights in various provisions. This was not novel. Among those rights was free speech, and I think Scalia laid out a history that it was. But a more general premise is much for our First Amendment is not originalist. This is an entire area we've deviated from original meaning. The Blackstonian method of prior restraint, right? The idea was you can't stop someone from speaking. That was the common law. Them for all day. Give you an example: New York Times against Sullivan, right? This is the defamation case. This entire actual malice standard that you can't sue a public official for libel. This is nowhere to be found in the Constitution yet. It's so firmly ingrained. I think in the free speech context, we've drifted far away from original meaning. Something to having corporations having free speech rights back at the time of the founding. Thank you for the question. Yes, sir, in the back.
Can I pivot and ask a more general version of the last question? And this is from Professor Sanders. Evolving constitution, subject to the same other criticisms that you raised about originalism as well. So the fact that different people who believe in the living constitution sometimes disagree about what the right result is. Science and psychology and ethics just as contestable and subject to different points of view. In other words, all those points, you're absolutely right as a descriptive matter about originalism. Isn't the same thing true about make it up as you go alongism or whatever the alternative is?
Well, first, I disagree with the idea that it's make it up as you go along. It's David Strauss says, yes, we start from the text, but the text is of almost no relevance in most of our most controversial issues today, like abortion and race and gay marriage and so forth. It is, it's the common law method. You teach criminal law, you know how the common law evolved. And sure, in many great common law cases that you read in criminal law, torts and property, there were vigorous dissents, there were majority and minority views among the states. I think the difference is that the living constitution, because it is centered around building on precedent and the incremental extension of precedent, that in any given I don't think it claims that in any given decision, right or wrong answer. I think the living constitution, the common law method, plays more faith in the idea that in the long run, over time, judges consulting the text, consulting precedent, aware of empirical knowledge about the world around us, will move toward the best answers.
So actually, I disagree. There is a provision in the Constitution which covers everything Steve just said. Article 5 I'm sorry, I screwed up my thunder. Article 5 lets you change the Constitution. It's been done many times. I'll give you an easy example, right? The 14th Amendment was passed, which says we guarantee rights and equal protection. Famously, one tried to go vote, says, look, all persons, I'm a person, let me have a vote. They said, no, you can't. So what happens, Congress ratified decades later the 19th Amendment, giving them the franchise. It works. We have an issue. People amend the Constitution. This again may blow your mind, but you do not need the Supreme Court to protect gay rights. You don't. You do not need the Supreme Court to protect racial rights. It doesn't. Those things are all illusory. In law school, all you study are opinions. You don't study elections. You don't discuss statutes. Civil Rights Act, 1964, that's where we desegregated schools. How many states were legalizing gay marriage before Bergefell? A number. And it had decided Bergefell, that number keep trickling up slowly. See, maybe the best results you get there eventually. You don't get there right away. A decision from Justice Kennedy, but you get there. If I leave you with nothing else, my federal society Panera lunch, right? Courts are not the answer to all your questions. You can achieve the best results without. Yes, sir.
Just to follow up on your point, though, I mean, if in fact you think of originals in the Borkian old-fashioned way, it's kind of a default to democracy. Basically, the Borkian view, and I think Richard Kay to some extent is still there. If there is a clear original right, yeah, we ought to protect it. And I think more in the original intent sense, and let the people govern their own destiny. With the Second Amendment, rights, we can appeal to legislatures. The NRA has enormous political power to do so, and they don't have to regulate guns, just as they don't have to regulate marriage. So I don't see how the originalism, non-original, sort of the aggressive originalism fits into, support for democracy as you just described it, and then into the political process.
Thank you for the question. So the short answer is it's in the Constitution. It's enumerated. The Second Amendment protects an individual right to keep and bear arms. There's no question democracy can violate it, no more than can violate the free speech or the warrant clause. The debate is over what the meaning of the Second Amendment is. But I want to address the question also.
The point is, if in fact it is ambiguous.
Right, I don't see.
5-4 debate between Scalia and Stevens suggests at least it might be, and the prefatory clause about the right of the people to have a militia, a well-regulated militia, would say in principle, you defer. You defer to the political process, and you don't have 5 justices trumping.
Okay, so I appreciate the question. I don't think it's ambiguous at all. But even assuming it is, Judge Bork hasn't been in the FedSoc in some time. He passed away a number of years ago, but he hasn't been in vogue. I, as Steve mentioned, am in the Randy Barnett School. And Randy says, rather than having presumption of democracy, you have a presumption of, and that when reading the Constitution in case of ambiguity, the tie goes to the individual. I think I agree with Steve on more cases than he probably suspects. But the general notion is when you have a conflict between the state and individual, tie of ambiguity goes to the individual. In this case, it goes to the individual right to bear arms.
Harp on people, specifically Stevens, for using this, decided to kind of seems almost assert the same principle and kind of debate silly on its own terms. And he often, or even when he called out Dworkin many times in talking to the Georgia Constitution, you're essentially just getting the same thing of what is liberty and using that as the guidestone.
The difference is the conception of liberty we have is one of historical one, in the sense of positive rights, for example. Like I wouldn't say recently about a right to education. These cases are all over the place, right? Can the court supervise the right to education? I would say no, that's not a right that was known at 1868. The right to bear arms? Yeah, that was something that was known. So I would have a historically granted conception of liberty. But there's a great quote from Abraham Lincoln. I'm paraphrasing. My conception of liberty is different than your conception of liberty. And this work can do a lot of variance depending on how it's interpreted.
I was just going to say
Thank you.
Very interesting, and there's a lot that the feeling about originalism. I do think a little bit in the description of Savior, I think from the court not doing its job. And it was because Governor of Arkansas, the state National Guard, to stop desegregation with the court order. So Eisenhower federalized those troops, and it turned into a military skirmish over the Supreme Court's ruling. That could have happened anyways, but Eisenhower wasn't just desegregating the schools, it was because he was forced to by the Supreme Court. I mean, he regretted on the court every day for the rest of his life, probably in part because of this. I mean, so if the answer here is that eventually these things will change, you just have to have faith in the political process. How long do you think people should be willing to wait for like school desegregation?
Desegregation take? There are still orders today pending.
Yes,
Yeah,
I mean, we
still today, 2016.
absolutely, but without it, that's only because of the original Roberts Court desegregation. I mean,
I think the court.
I mean, I don't mean to
Yeah.
that you need to solve a huge social problem this way, but the courts didn't play a role there.
I think society changed. So here's actually a good way of wrapping up, because I think I'm almost out of time. I appreciate the question. I'll wrap up on this point. Departmentalism, right? The court is not the only branch that gets to interpret the Constitution. I firmly believe in this. Call it popular constitutionalism or what you will. We can interpret the Constitution, and our change, right? Today, I think if you took a poll, I haven't taken, but if you take a poll saying what percentage of people think that schools should be desegregated, it'd be close to 100% or something, you know, perhaps awfully close to it. Courts anymore to legitimate that constitutional decision. Perhaps the courts jumped out ahead, but it was only when the American people got there. Number I know of. A question is asked: are you okay with interracial marriage? Right? Would you want your son or daughter marrying from the opposite race? And this has been polled every year since the 60s. And that number, man, has gone up. It's almost 100%. Whether or not loving was correct as a matter of constitutional law, the American people have embraced this as a constitutional norm. The decision, did it not? But we can make constitutional decisions for ourselves. It maybe takes too long, right? Maybe people are we want justice now. No justice, no peace, whatever the thing is, right? We want it now. We have a long republic. It's been 200 years. Might be a process, but I think more often than not, it's the political process that achieves the best. The courts. Thank you for your attention. I really appreciate your time. Thank you.